The Clerk will now proceed to read the orders of the day.
Arbitration Bill Lords, second reading.
Whip, 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 whip. Now. Minister to move second reading. Minister.
Thank you, Madam Deputy Speaker. I beg to move that the bill be now read a second time. Madam Deputy Speaker, I am pleased to be opening the second reading debate on the Government's Arbitration Bill. The legislation is a direct response to recommendations made by the Law Commission of England and Wales in its report on arbitral reform published in September 2023. And would, if enacted, make targeted reforms to the Arbitration Act 1996, which governs arbitration in England, Wales and Northern Ireland. Scotland has its own devolved arbitral framework, the Arbitration Scotland Act 2010, which this bill, of course, does not affect. Arbitration is a major area of business activity. For example, the Chartered Institute of Arbitrators, headquartered in London, has more than 17,000 members across 149 countries. As the House will know, arbitration is greatly valued by individuals and businesses alike as an alternative to going to court, giving parties the ability to appoint a private tribunal to resolve disputes by issuing a binding and enforceable award. For example, when parties enter into a commercial contract, it is common to find a clause which provides that any disputes will be resolved through arbitration in London, in this great capital city, rather than through litigation in court. This is often true, even where the contract has no other connection to the UK. Such is the prestige of arbitration here, Madam Deputy Speaker. Furthermore, thanks to international convention, commonly called the New York Convention, dating from 1958, arbitration awards made in the UK can be enforced anywhere in the world. Studies suggest that such enforcement is often faster and more reliable than seeking instead to enforce court judgments. The New York Convention may date from 1958, but arbitration has, of course, been a feature of our justice system for centuries. Arbitration was a common way of settling disputes back in Anglo-Saxon times, Deputy Speaker. Then it was largely a public affair, with enforcement through community pressure. By Norman times, parties could choose their arbitrator, someone known to both sides and well placed to facilitate a reconciliation. In the 14th century, the opposition spokesman is enjoying my little canter through the historical background, which I'm sure the massed attendance this afternoon is also enjoying. So in the 14th century, we return to the 14th century, the mayor and aldermen of London set up, in effect, an arbitration centre here in this great city. This also provided services to foreign traders whose dispute had no other connection to England. Arbitration then grew in Elizabethan times, and by the mid-18th century, arbitration clauses were very common, as were professional arbitrators. It is said that our first Arbitration Act, the Arbitration Act 1698, was single-handedly drafted by the famous political philosopher John Locke, after being tasked by the then Board of Trade to devise a scheme which would help merchants reach satisfactory settlement of their disputes. John Locke's arbitral framework fitted on 1 to 2 sides of paper, which is a real achievement, isn't it? If only we could emulate that today. But things have got more complicated, therefore more precise. Arbitration has come a long way since then, though we salute John Locke and his efforts in setting us on this journey.
Quite right.
Today, of course, arbitration happens in a very wide range of settings, from rent reviews through commodity trades and shipping to international commercial contracts and investor claims against states. In each instance, it enables parties to resolve the dispute at hand and move on from it. The parties can choose a neutral venue to resolve their dispute. They can choose trusted arbitrators or arbitral institutions to preside over the proceedings. I'm just going to grab a glass of water, if I may. Thank you. Thank you, Madam Deputy Speaker. Appreciate your indulgence. And I add with emphasis that some of the world's leading trade and arbitral institutions are headquartered here in London. I may have mentioned that before, but we need to be proud of this. From the aforementioned Chartered Institute of Arbitrators, through the London Court of International Arbitration, to important specialist organisations concerned with matters such as shipping and trade in grains, oils and sugars. To resume, parties can tailor the arbitration process to their own needs, and all this results in an award which is international enforceable. At the same time, this process is respected for its integrity. At least that is the position here in the UK, thanks in large measure to the regulation of arbitration through the Arbitration Act 1996. The Act ensures that arbitration is conducted in a way which is impartial, which is fair, and without unnecessary cost and delay. The English courts, which command much respect worldwide, retain a supervisory jurisdiction. Building on its extensive history for arbitration, and thanks to its legislative framework, London has, of course, become the world's leading destination, Madam Deputy Speaker, for international arbitration, highly respected as a neutral venue for resolving disputes across the world, something of which we all take immense pride, and rightly so. In fact, the Law Commission, Madam Deputy Speaker, estimates that at least 5,000 arbitrations take place in England and Wales each year, directly contributing at least £2.5 billion a year to our economy in fees alone. So arbitration is part of our growth agenda. This bill today is part of our growth agenda for our great country. As arbitration is, however, a largely private affair, we may speculate that arbitration's direct value is likely even greater than that £2.5 billion. But also, arbitration is an important offering in our country's international business package, one that includes legal services, banking, insurance and trade. It is a great advantage of our jurisdiction that business can be done here in the knowledge that when legal disputes arise, they can be resolved swiftly and fairly. We enjoy a worldwide reputation for quality, independence and ethics of our legal professions. It's no surprise that arbitration here in London is a showcase for that, and it is very much in demand. Madam Deputy Speaker, given that the Arbitration Act 1996 is approaching 30 years of age, the previous government rightly asked the Law Commission to undertake a thorough review of this legislation back in 2021. They were tasked with determining whether the 1996 Act required amendment to reflect modern practices and maintain its effectiveness in a growing global market, when competing jurisdictions have already updated their own arbitral frameworks. The Law Commission were painstaking in their review, carrying out the commission given to them by the previous government, and I pay tribute to the members of the Law Commission for their painstaking work on this matter, from which we all benefit. An initial consultation paper was published in September 2022. It laid out their analysis of the law as it stood and proposed a small number of areas for reform. They received responses to that consultation from a broad and an expert base of consultees, including individual practitioners, academics, specialist bodies, and international firms and institutions, as well as, of course, our judiciary. Taking this feedback on board, the Commission refined its proposals and published a second consultation paper in March 2023. And after yet another round of engagement, final proposals and a draft bill were published in the September of 2023. As I said, this has been painstaking and thorough, and we need to credit everybody involved in that, including the party opposite, for their leadership of this process during that time. It is a testament to the longevity and flexibility of our arbitral framework that only targeted updates were recommended, with the Law Commission concluding that while some modernisation of the 1996 Act was needed and was desirable, Madam Deputy Speaker, you'll be pleased to know root and branch reform was not. And it is a testament to the Lord Commission's thorough consultation that the proposed bill commands such support in arbitral and legal sectors. I cannot resist adding that the work has been watched carefully by our competitor jurisdictions abroad. The Law Commission's report was cited by the Singapore Court of its own initiative, and in the last few months, seeing the positive developments here, France has announced a need to review its own arbitration laws. We lead the way, Madam Deputy Speaker. We lead the way, and this bill will ensure we stay ahead. Honourable and right honourable members will be aware that the previous government introduced an arbitration bill into Parliament in 2023, which also sought to implement the Law Commission's recommendations. That bill had made its way through committee in the other place before Parliament was dissolved for the general election. The legal sector was emphatic in expressing the view that the proposed reforms are vital for updating the arbitral framework and making sure our jurisdiction remains competitive. We are first in global class on arbitration, Madam Deputy Speaker. This bill will ensure we stay first in global class. It is a view with which the government agreed wholeheartedly, not least because of our commitment to fostering economic growth in our country. As such, this legislation was introduced to Parliament at the very earliest opportunity as a bill in the other place in July last year, one of the first acts of this government after the general election. I am pleased to see it finally arriving to this House, as I'm sure that you are, Madam Deputy Speaker. It is worth saying that the 1996 Arbitration Act boasts some key strengths. It provides flexible procedures that allow parties to shape proceedings to best suit them. Parties can, for example, arbitrate their dispute with one of our jurisdiction's many world-leading arbitral institutions, who have developed procedures that parties trust will deliver a fair and timely outcome. Our current framework also permits effective recourse to our courts where needed. Parties can request that our courts determine a preliminary matter in the arbitration, such as jurisdiction, or indeed later challenge an award produced from arbitration. Arbitrators can similarly apply to the courts to assist their proceedings, such as by enforcing their orders. At the same time, that regime of court support is carefully balanced to prevent parties from dragging their feet and relitigating cases. This gives parties huge confidence that arbitrations can take place in our jurisdiction, that they are both efficient and fair. Many of this bill's reforms are designed to build on these strengths, the strengths of the 1996 Arbitration Act, Madam Deputy Speaker. I'm going to just go through the key clauses now to draw attention to the matters of each clause, because I can tell that people are deeply interested in just checking through the detail so that we know exactly what we, should we move to a vote, exactly what we're voting upon.
Quite right.
I'm pleased to see the opposition spokesman giving me a willful eye of encouragement, for which I'm duly grateful, and I thank him. Clause 1, we start at the beginning. Clause 1 will make it much simpler to determine what law applies to an arbitration agreement. Currently, the rules for identifying the governing law are found in the common law and a recent decision by the Supreme Court. That decision shows both immense learning and the complexity of the current approach. The Supreme Court were split in their judgments, whose approach was different from those in the Court of Appeal, which was different from that at first instance. Instead, to make the law clearer and more predictable, Clause 1 provides that the governing law will align with the legal location, that is, the seat of the arbitration by default. This will ensure that arbitrations, where seated in England and Wales and Northern Ireland, will be fully supported by our law, which is among the most supportive of arbitration globally. Clause 2, Madam Deputy Speaker, codifies a duty for arbitrators to disclose circumstances which may cause doubts as to their impartiality. This will codify the common law. and it will align domestic law with international best practice, such as the UNCITRAL model law, which I add our own expert lawyers had a major hand in drafting, and whose influence can be found in other jurisdictions as far apart as Scotland and Switzerland. It will promote trust in arbitration by promoting trust in integrity and impartiality of arbitrators. So, Madam Deputy Speaker, we move on to clauses 3, and for the interest of moving things forward a bit more briskly, clause 4 as well. So clause 3 and clause 4 will support arbitrators to make impartial and proper decisions by extending their immunity against liability when they resign for good reason or are removed for no fault of their own. This will support arbitrators to make robust and impartial decisions without fear. Clause 5, Madam Deputy Speaker, clarifies that there are 2 pathways for a party who wants to challenge the jurisdiction of the arbitrators. In other words, who wants to question whether this dispute should be arbitrated at all. Either that party can apply to the court for an early ruling, or they can wait until the award is issued and then go to court. And clause 5 clarifies that they cannot do both. It's an either or, Madam Deputy Speaker. Clause 6 ensures that where arbitrators agree that they should not be hearing the dispute after all, they can still award the costs incurred to that point against the party that generated those costs. Clause 7 will allow arbitrators to adopt expedited procedures to dispense with issues that have no real prospect of success. This will align with summary judgments available in court proceedings and will make arbitrations more efficient. We move, Madam Deputy Speaker, seamlessly on to Clause 8.
Very good.
Clause 8 will help emergency arbitrators. Now, emergency arbitrators are those who are appointed on a temporary basis while the full tribunal is being established, which is a process which can sometimes take weeks. So they are very important in arbitration terms, Madam Deputy Speaker. They are often tasked with vital preliminary matters, such as preserving evidence or assets, and are important for ensuring arbitrations can proceed smoothly. Emergency arbitrators are a practice that postdates the 1996 Act, so our framework did not make explicit provision for them. So obviously looking again gives us an opportunity to have a look at their role. Clause 8 empowers these emergency arbitrators to better handle urgent matters and ensure compliance with their directions by equipping them with final orders and court enforcement. This will give emergency arbitrators the same pathways to enforce their orders as other arbitrators and will enhance their effectiveness. Clause 9, Madam Deputy Speaker, provides that court orders made in support of arbitral proceedings can be made against third parties. This aligns with the position in court proceedings. For example, it would enable a party to arbitration to get an order freezing assets held by a third party, for example, a bank. Clause 10 ensures that when a party challenges an arbitral award at court, the court has the full range of remedies available regardless of the pathway. Clause 10 irons out discrepancies which courts and practitioners have otherwise sought to work around. Moving on to Clause 11. Clause 11 will provide more efficient court challenges to the tribunal's jurisdiction through rules of court that will prohibit repeating evidence and arguments already debated in front of the tribunal. This will avoid such challenges becoming full rehearings, reducing costs and delays. Clause 12 I can deal with pretty quickly. You'll be pleased to know, Madam Deputy Speaker. Clause 12 ensures that the time limit for challenging awards is consistent across the Act. Clause 13. Clause 13 corrects a rare example of a drafting error. What the Act meant to say was that court orders could be appealed, but in some cases there would be restrictions. What it actually said was that court orders could only be appealed where there were restrictions. To their credit, the Judicial Committee of the House of Lords spotted this error. They spotted it and interpreted the statute as it was meant to be read. We take this opportunity, Madam Deputy Speaker, to correct the drafting to reflect the judicial ruling. So a bit of useful tidying up. Clause 14 streamlines the requirements for applying to court to obtain preliminary rulings from the court on questions of law or on whether the arbitrators have jurisdiction to hear the dispute. Early rulings such as these from expert judges can save time and cost. Madam Deputy Speaker, I am getting towards the end of going through the clauses. In fact, I have come to the last and final clause I wish to comment upon, which is Clause 15, which probably, Madam Deputy Speaker, you'd worked out because that usually comes after Clause 14. But there is no Clause 16, so this is the final clause. Clause 15 repeals provisions which were never brought into force, simply to tidy up the Act. These provisions would have meant slight differences in approach between domestic arbitrations and international arbitrations. In the event they were never actually used or needed, as I said, they were never brought into force and there remains no demand for them. Our arbitration law is first class and applies equally to domestic as to international arbitrations. So removing this clause is a helpful thing to do to tidy things up. Madam Deputy Speaker, in sum, the bill will greatly improve the arbitral process in our jurisdiction and further cement our position as a top global business destination where legal disputes can be devolved fairly and quickly. It has already gone through the other place where it received considerable examination and support from noble and learned lords, including many experienced arbitrators. There are apparently a lot of experienced arbitrators in the other place, and they brought their knowledge, their experience, their expertise to the debate in the other place, for which we are very grateful. Indeed, I should emphasise that it has been reviewed by members of the other place twice, not once but twice. The first time scrutiny was provided by a committee led by the noble and learned Lord Thomas of Cumgeath, which took further evidence from expert stakeholders. The several technical improvements made to the previous bill because of that work are retained in this bill. This time, the bill was reviewed on the floor in the other place, where the government amended Clause 13 to fix a long-standing error in our framework on arbitral appeals. To conclude, Madam Deputy Speaker, because I think I've been quite thorough in covering the ground on this, and I hope that all members feel that they have got a really good understanding of the issues behind this bill today and why we need to take the steps that I am urging the whole House to take, but I'm coming to my conclusion. So that this time the bill was reviewed on the floor in the other place where the government amended clause 13 to fix a long-standing error in our framework on arbitral appeals, as I have just said. And finally, I second the remarks made by Lord Thomas during the bill's third reading when he said, "We must find a means of doing this very rapidly, as we must keep English law attractive and at the forefront of use internationally for the benefit of our whole economy." I hope the House agrees, and I beg to move that the bill be now read a second time.
Tour de force from the 1400s. The question is that the bill be now read a second time, and I call the Shadow Minister, Dr. Kieran Mullan.
Thank you, Madam Deputy Speaker. Now, I rise today on behalf of the opposition to support the second reading of the Arbitration Bill. As the Minister has laid out, arbitration is a cornerstone of the UK's legal and economic landscape, contributing significantly to our reputation as a global hub for dispute resolution. This bill seeks to amend the Arbitration Act 1996 to ensure our framework remains world-leading and fit for purpose in a rapidly evolving global business environment. Arbitration plays a vital role across both the domestic and international spheres. It's employed in areas ranging from family law and rent reviews to commodity trades, shipping and investor claims against states. With over 5,000 arbitrations conducted annually in England and Wales, the process directly contributes to more than £2.5 billion to our economy in arbitrator and legal fees, whilst also supporting wider sectors such as banking, insurance and trade. And the Minister today used the opportunity to cover quite extensively the long and distinguished history of arbitration in our judicial system. And we all agree that London stands proudly as one of the world's most preferred seats for international arbitration alongside Singapore. Maintaining this position is no accident. It reflects the strength of our legal system, the confidence of global businesses in our expertise and the robustness of the original 1996 Act. However, as other jurisdictions modernise their arbitration laws, we must ensure that ours remain cutting edge to safeguard our competitive lead. The previous Conservative government rightly recognised this need and in March 21 tasked the Law Commission to review the Act. And I want to thank all of those at the Law Commission involved for the hard work and excellent work that they delivered in this regard. After extensive consultations and input from stakeholders, the Law Commission published its final report and draft bill in September 23, identifying targeted reforms to enhance our arbitration framework. A bill to deliver those forms was introduced by the Conservative government in November 2023, and I want to thank the Minister for his acknowledgement of the work the previous government did in this regard. But of course, its progress was interrupted by the general election. The opposition commends the government for reintroducing this bill swiftly in light of the broad support. And I would just say to observers of the chamber who might notice that we have a quiet chamber today, that this is obviously, after all, the world's first debating chamber. And I think the lack of attendance is a reflection of the deep and considered consensus and lack of debate around the important needs of this bill and what it's seeking to achieve. I want in particular to take this moment to thank Lord Bellamy for his contributions as the original sponsoring minister of the original bill and for his continuous and important contributions in the development and improvement of this bill. And I'd also like to briefly thank Lord Hacking for his contribution in the debates of this bill in the other place, particularly on the issue of corruption. We appreciate this valuable input and agree that this matter does warrant further consideration, even if we agree that ultimately the need to get this bill onto the statute books and all the benefits it brings means it wouldn't be appropriate to do that through the current legislation, something that we should continue to monitor and revisit. The Arbitration Bill introduces a range of reforms designed to improve clarity, efficiency and fairness in arbitration proceedings. These reforms address practical changes while reinforcing the UK's position as a global leader. Let me highlight a few key provisions, as the Minister has explained in detail, that make this bill significant. Firstly, the bill addresses long-standing uncertainties in the legal framework, particularly regarding arbitration agreements where no jurisdiction is specified. By defaulting to the law of the arbitration seat, the bill aligns with international norms, thereby enhancing predictability and clarity for parties involved. Secondly, it strengthens the integrity of arbiters. By codifying the duty of impartiality and disclosure, as clarified in the landmark Halliburton v Chubb case, the bill ensures greater transparency and fosters trust in the arbitration process. And finally, the bill promotes procedural efficiency. Provisions such as allowing summary awards, recognising emergency arbitrators and streamlining jurisdictional challenges represent vital steps towards making arbitration more accessible and efficient for all stakeholders. These are just some of the many commendable reforms in this bill which aim to modernise the 1996 Act and ensure arbitration remains an attractive and effective method of dispute resolution. The opposition developed the original bill and supports this bill to ensure the UK's ongoing leadership in arbitration. However, we of course remain committed to scrutinising its provisions during the committee stage to ensure they achieve their intended goals without unintended consequences. Madam Deputy Speaker, I commend this bill to the House and look forward to hearing the contributions of the other opposition spokespeople in this debate.
I call the Liberal Democrat spokesperson, Olly Glover.
Thank you, Madam Deputy Speaker. And can I thank the Minister for his comprehensive history of arbitration in the United Kingdom. It's been a long time since I've considered John Locke, having studied him as part of a history of political thought paper, which feels almost as long ago as the survey that the Minister outlined. The Liberal Democrats welcome the reintroduction of this bill and indeed its wide support across this House. As the Minister said, the Arbitration Act of 1996, which governs arbitration in England, Wales and Northern Ireland, is over 25 years old. And as he also said, the Law Commission estimates that there are at least 5,000 arbitrations annually in England and Wales, worth at least £2.5 billion to the economy in arbitrator and legal fees alone. Arbitration is also important in supporting a whole range of business activities, as have been outlined. An effective legal and dispute resolution process is one of the underpinnings of a successful democratic and trading nation, and something of which the United Kingdom has historically been proud. This bill will help to maintain that status based on recommendations from the Law Commission and, as the Minister has said, particularly London as one of the great centres of international arbitration. This bill implements recommendations made in the 2022-23 Law Commission review of arbitration law to support more efficient dispute resolution. And the legal sector has widely supported the targeted reforms in the bill, with positive feedback from public consultations held by the Law Commission. There were two key issues raised during committee stage in the other place, which we are happy to see resolved now in this bill. The first was on the subject of corruption risk. The Liberal Democrats pressed the government to provide more information to ensure that confidential arbitration is not abused to hide corruption from public scrutiny. And we thank the Minister for detailing the actions being taken by arbitral institutions to mitigate against the risk of arbitration being misused, and we were satisfied with the reassurance given. The second concerns the right of appeal. Liberal Democrats were glad to support the two amendments tabled by the government to correct the drafting of Clause 13, following concerns that the original clause provided a more limited access to the Court of Appeal than was established in case law. In conclusion, Liberal Democrats are very pleased to support this bill, and given some of the other discussions in this House today, we welcome an uncontroversial contribution to the economic growth that this country needs.
We now come to wind-ups, and I believe that the Shadow Minister has a few comments he wishes to make. Dr.
With the leave of the House, just very briefly, I focused my remarks earlier, particularly on the bill, as you might expect, but I want to take this opportunity when we have important matters like arbitration before the House and have the Minister's attention, just to reiterate, first of all, our thanks to everybody involved, both in this bill and the previous bill in both houses, but in particular Lord Hacking and his work in highlighting the other issues, and just to encourage the Minister to recognise that whilst this bill is welcomed and will be positive, there are other issues that the government will need to continue to work on. As I mentioned earlier, the interplay between arbitration and corruption, the need for expedited hearings, the role of third-party funding and the authority to mandate mediation between parties. So on those matters, even if the Minister doesn't have an immediate response, I'd welcome future work from the government in these areas. Thank you, Madam Deputy Speaker.
And I call the Minister, Sir Nicholas Dakin.
Thank you, Madam Deputy Speaker, and I thank all members for their contribution to the debate. Can I, first of all, thank the opposition spokesperson for recognising, as we do, the work of Lord Bellamy and Lord Hacking and other peers in the other place, and really everybody that's contributed to where we've got today, and also very much welcome what the Liberal Democrat spokesman has said in relation to the tackling of those issues through the process in relation to giving greater confidence about tackling corruption risk and the issues around the right of appeal. Very grateful for the constructive way in which this debate has been pursued. The bill mirrors that of the last government's, save for two changes, which I will note here for completeness. The first, as I mentioned in my opening speech, was the amendment to Clause 13 to better reflect the case law on appeals. The drafting error it fixed was as follows. There was a drafting error in Section 18 of the Senior Courts Act 1981 and in Section 35 of its Northern Ireland equivalent, the Judicature NI Act 1978, which suggested that appeals to the Court of Appeal under Part 1 of the Arbitration Act 1996 would only be permitted if expressly permitted in the 1996 Act. However, case law established that the intended regime for appeals under the 96 Act was to permit appeals to the Court of Appeal unless there is provision in the 96 Act that adds an explicit restriction on those appeals. So I hope that deals with that issue. Therefore, Clause 13 now corrects the drafting error identified in the House of Lords judgment in Inco Europe and First Choice Distribution and makes clear that appeals from High Court decisions under Part 1 of the Arbitration Act 1996 may, subject to provision in that part, be made to the Court of Appeal. This also required a slight amendment to the long title to reflect that change. The second change was to Clause 1, which we made prior to the bill's introduction to Parliament. This was to address concerns about the effect of Clause 1 on arbitrations between investors and states, in particular those which follow from an open invitation to arbitrate made in a trade agreement or in a domestic legislation. The current position is that these arbitrations are governed by international law, Madam Deputy Speaker, and foreign domestic law, and sector feedback made clear that this is what should continue. Therefore, the change we made provides that new section 6A(1) of the Arbitration Act 1996 does not apply to arbitration agreements derived from standing offers to arbitrate contained in treaties or non-UK legislation. Wish to interject? No, just pause for a little reflection while I gather my thoughts on the other issues to do with arbitral corruption. And I'm sure the honourable member opposite, for whom I have the highest regard, would not want me to skimp on dealing with arbitral corruption, which has been raised by both of the speakers in the debate so far. So I'm encouraged by his nodding. Corruption is an issue we take very seriously, Madam Deputy Speaker. However, we have concluded that arbitral corruption is not caused by any issue with our domestic arbitral framework. The Arbitration Act 1996 and the common law already provide remedies to deal with corrupt conduct. The courts are empowered to set aside arbitral awards where there are serious irregularities, as they have done recently in the sort of very strongly known case of Nigeria and P&ID. Also, arbitrators are under a statutory duty to be impartial and reach a fair resolution of the dispute, and they can issue an award that prevents the corrupt party from benefiting. And although arbitration procedures are often private, corruption can be exposed. Common law allows an exception to confidentiality when disclosure is in the public interest. However, there is a need for arbitral practitioners and institutions across the world to ensure their practices are continually developing to weed out attempts to exploit them. We will support and keep track of initiatives underway, such as that of the International Chamber of Commerce's Anti-Corruption Task Force, and we will engage with the sector to adopt the very best practices as they are developed. So I hope that assures honourable members on that very pertinent issue which they both raised. So, with the leave of the House, I give my sincere thanks to honourable and right honourable members who contributed. It has been a measured and helpful debate which underscores the broad support for this legislative programme. I'm happy to have heard so much support for this bill, particularly those contributions emphasising its importance in economic growth. Our legal services are a vital element of our economy, both for creating favourable domestic business conditions and attracting investment in the UK. And this government will continue to support them. I will re-emphasise that these reforms are very much appreciated. There are many businesses who will be deciding whether to designate London as their seat of arbitration versus competitors such as Singapore, Hong Kong, Sweden or Dubai, who have updated their arbitral frameworks in recent times. And this decision is not just to settle disputes via arbitration now. Arbitration agreements are often preemptive, so these businesses will be making a decision as to where and how disputes may be settled many years in the future. For the past quarter century, our Arbitration Act and our English law have been a key draw that make our shores the natural choice for arbitration. In 1996, we created a truly world-leading legislative framework, which contributed to London becoming the preferred forum for arbitration proceedings from across the globe. We must maintain our leading position and continue to attract business to ensure economic growth. It was therefore important that these measures sought only to improve the arbitral process and promote trust in arbitration. It would have been no good had these reforms created red tape. We wouldn't want to see that. Arbitration must remain a quicker and a more flexible means by which to resolve a legal dispute versus going to court. But also it was key to promote trust in arbitration, to ensure that proceedings on our shores remain robust and respected internationally. The Law Commission has done a brilliant job, a superb job, Madam Deputy Speaker, and they need to be commended for it, with reviewing our framework line by line and seeing where such improvements can be made. This bill contains, as I have said, the expertise and wisdom of a myriad of practitioners, experts, firms, judges and others. If I may indulge in sharing some of the supportive quotes by the sector about the Law Commission's work. Well, I've only got a few, but I think the House would be the poorer for not hearing these quotes. So I feel it's important to share them, and there are more available. I will just restrict to just these few. Okay. The Bar Council, we'll start with the Bar Council, said, "We welcome the Law Commission's characteristically careful and balanced review of the Arbitration Act, and we support the proposals for reform which it makes. It is extremely important that the Government finds parliamentary time," we're doing that, "for the short bill which the Law Commission proposes. London has a well-deserved reputation as the foremost centre for international arbitration. It is important to legislate to make the modest changes to the arbitration regime which the Law Commission has recommended in order to maintain and enhance that reputation." The Chartered Institute of Arbitrators, Madam Deputy Speaker, said, "The Chartered Institute welcomes the proposed changes, a majority of which are in line with our recommendations, which were informed by input from our membership. It is a sign of the Arbitration Act 1996's strength and value that only specific changes to ensure that Act remains current have been recommended as opposed to an overhaul, as well as underpinning the attractiveness and competitiveness of London as an arbitration seat. The Act forms the basis of legislation in many other jurisdictions, including global significance to this development. The Chartered Institute of Arbitrators worked closely with the UK Law Commission to inform the review. We support regular review of such legislation to ensure arbitration remains effective, fit for purpose and a viable means of justice in the modern world." White and Case LLP said, "We expect that the amendments proposed by the Law Commission will promote the efficiency and finality of arbitration proceedings whilst not unnecessarily introducing drastic reform to existing legislation. The report, therefore, is to be welcomed as a positive, incremental step in maintaining London's position as a major centre for international arbitration and dispute resolution more generally." And the last quote, Madam Deputy Speaker, from the many positive comments that have been received on what we're doing today and what the Law Commission's work. Herbert Smith, Freehills LLP, said, "There can be no suggestion that any changes are being made for change's sake. The Law Commission has respected the importance of this legislation and sought only to make changes that are necessary if enacted into law. They will continue to ensure that the arbitration legislation of England and Wales maintains its market-leading status." And that's what we all want, Madam Deputy Speaker. We want this arbitration bill, which began under the last government, completed under this government, to maintain our market-leading status. And that's what we're determined to do by working together across this House. These are, I assure the House, only a small sample of those who engaged with and supported the Law Commission's review. However, I will also highlight that these were comments made almost a year and a half ago now upon the publication of the Law Commission's final report. Whilst it is indeed the case that law reform can take some time, this government is committed to ensuring these reforms find their way onto our statute book as quickly as possible. We must ensure that this bill faces no further delay, Madam Deputy Speaker. These measures must now proceed at pace through the House. Dispute resolution matters. Disputes which go unresolved are bad for the parties and have knock-on consequences for everyone else. At best, disputes distract from firms getting on with their business and individuals getting on with their lives. At worst, the slow and stressful impact of legal disputes can have much greater impacts elsewhere. Businesses may have money tied up in litigation that could and should go towards investment. Individuals may find that a protracted court battle with its costs and delays may lead to sickness, which of course will have its own knock-on effect on economic productivity. Resolving disputes, Madam Deputy Speaker, allows everyone to move forward. All the more so if disputes can be resolved by a process which is trusted and respected, and which can be tailored flexibly to the needs of those involved. It is no wonder that arbitration has proved such a popular method for resolving disputes in the UK, and why UK arbitration has proved such a popular method for resolving disputes worldwide. I will also take a moment to compliment the other excellent forms of dispute resolution on our shores, Madam Deputy Speaker. In the construction sector, many disputes by default will go to an expedited adjudication with experts, allowing for a quick determination that allows the project to proceed without further delay. We also boast an excellent network of ombudsmen who deal with all matters of disputes, such as consumer matters, Madam Deputy Speaker. And we also have a growing mediation sector which in both commercial and family matters are expert at facilitating negotiation between the parties to come to a truly consensual resolution to the dispute. This bill will enact long-awaited reforms to our arbitration law framework, which will enable more efficient dispute resolution for domestic and international parties alike. It will attract international legal business and promote UK economic growth, not just directly because arbitrations are happening here, but because it promotes the UK as a one-stop shop for business. Our arbitrations are respected, so too our lawyers engaged in arbitrations, lawyers who then are engaged for transactional businesses, business which is funded by our banks and underwritten by our insurers and mediated through our trading houses which also offer arbitral services in a mutually reinforcing offering. This bill ensures that our arbitration law is cutting edge, and as I said above, it has attracted attention the world over, serving as a reminder, Madam Deputy Speaker, of why the UK remains a premier destination internationally for businesses everywhere. This bill is therefore of great importance to the legal services sector, and it is of great importance to this government. I commend the bill to this House.
The question is that the bill be now read a second time. As many as that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Programme motion to move formally.
I beg to move.
The question is, as on the order paper, as many as that opinion say aye. Aye. Contrary, no. The ayes have it. The ayes have it.